The Honourable Amy Adams.
Thank you, Mr. Speaker. I noted in listening to the Speaker when he granted the urgent debate that he made particular reference to wanting to clarify the comments of the Prime Minister when he talked about most of the recommendations would be given effect to. And I want to speak specifically to that point because the comments the Prime Minister made were around simply the way in which the changes to the anti-money laundering laws were going to be delivered. And I want to be really clear about that there is certainly no intention that we won't be making the changes to the anti-money laundering law. But actually, sir, I think this urgent debate gives us a very good opportunity for me to clarify for this House exactly how that process is intended to happen and why we do think that there is a need to depart not on substance but on process from what the report said in this regard. So Mr Shewan in the report indicated that in his view to bring lawyers and accountants into the AML regime was a reasonably simple matter of issuing an order in Council to remove the exemption from the definitions regulations. Now, while I can understand that that might have an attractiveness in its simplicity, it simply is not workable and primary legislation is required. And let me just explain how that works. Currently, under the anti-money laundering law, we have a requirement that all financial institutions are reporting entities under the legislation, as in fact are all trust and company service providers, which I'll come back to later. But the definition of financial institutions, because by nature it is a very wide and brief that could encompass a lot of things, is then spelt out by the types of activities that they perform to make it clear that it was never intended that lawyers would be included in that first phase. The regulation simply made it very clear that lawyers were not caught by that definition of financial institutions. It was never intended that they would be, no one ever expected that they would be, and the exemption doesn't simply carve them out of the ledge, it just makes very clear what we had in fact passed at that time. To bring lawyers and accountants and real estate agents, for that matter, into the framework, as we absolutely are committed to doing, as I've announced and the Prime Minister has announced, you do need primary legislation, and that is the one point where we have a slight difference of approach from Mr Shewan. It cannot be done by his simple OIC process, although, as I say, I can understand the initial attraction of that as potentially an option. It simply doesn't work, and one of the core reasons is that you need to work out who the supervising agency is, you need to work out how that's been put in place, but most importantly, you need to deal with matters like legal professional privilege. That, sir, can't be done simply by an OIC process. Legal professional privilege is enshrined in the Evidence Act, it's enshrined in the Lawyers and Conveyancers Act, and I'm sure this House will understand very simply that to have an anti-money laundering regime, to have mandatory reporting requirements on lawyers and conveyancers and accountants and real estate agents, but the lawyers in particular, you have to have a framework which makes it very clear for them what their obligations are to report information that would otherwise be covered by legal professional privilege. That can only be done by primary legislation. So that's why the distinction, that is the point the Prime Minister was making, was that actually, while we absolutely are committed to bringing the reform in, the OIC process won't work. We are committed to the legislative reforms. We have already announced that we are accelerating those. I've said publicly it's my intention that we will have a bill into this House by the end of this year, and subject, of course, to the processes of Parliament, I want to see that legislation in place and in force by July of next year. Now, that is working at some pace, and let me just be very clear with this House, while we are working at pace, we do have to be careful to make sure that we get this right. This is a regime that will impose significant compliance costs on not just the sectors, but actually the New Zealanders who pay the bills of those sectors. Every time you buy a house, there will be more cost. Every time you go to your lawyer or your accountant, there will be more cost. Now, that's okay. We need to have a regime. We've all accepted that this is an important part of transparency and good accountability and financial oversight. But we have an obligation to ensure that the system works well, that covers what we need it to cover, and that those costs are no greater than they need to be. Every single New Zealander has an interest in seeing that happen, as do we. And, Mr Speaker, we have absolutely committed to the fact that we want to get this regime in place quickly, but no New Zealander would thank us if we imposed costs that was unnecessary and unwarranted and we could do it more efficiently. Let me just talk about one other aspect, which is that while the focus today is, of course, on foreign trusts as a response to Mr Sherwin's report, when we're talking about these amendments to the AML laws, and it's relevant because this was the very point that the Prime Minister said was the one bit where we needed to go on a slightly different road to get to the same place, actually foreign trusts are only one part of what we need to deal with AML legislation. When we bring lawyers, accountants, real estate agents into the framework, it's as much about the criminal activity of gangs and the like in New Zealand and the laundering of criminal proceeds, and the police have a real interest in ensuring that we can get access to far more of the suspicious financial transactions. So when we're working through these matters, while I know the focus today is on simply how the foreign trust part works, actually it's incumbent on us to make sure the regime works for all its intended purposes. And for that reason, sir, it isn't simply a case of carving something out and we've got an instant result. So that was the only point the Prime Minister was making. Yes, we agree with Mr Sherwin's recommendations on AML and the need to change those. Yes, we've already committed to making those changes. Yes, we're accelerating them, but to suggest that it could be done by OIC was where we, Order in Council was where we disagreed. And the process that we're on, the time frame we're on, actually I'm comfortable is as quick as we can get it without running the serious risk that the regime is either incredibly expensive, not workable or not comprehensive, and I don't think anyone would thank us for that. As part of that, I do want to see a select committee process in place. I think it's important that there is a full opportunity for people to test the framework, and I think this House would want to see it. So at this stage, it's not my intention to seek that the bill be pushed through all stages in urgency. I do think that there is benefit in a select committee process. As this House knows, there's a trade-off in that regard, and that is extra time before it is in place, but that is certainly my view at this stage. I want to talk about one other aspect of this in regard to the anti-money laundering component of the recommendations, and that is to make very clear that while lawyers and accountants and real estate agents are not in the regime as of right at the moment, what is in the regime automatically are these things called trust and company service providers. And Mr Speaker, I can tell you that currently there are 109 trust and company service providers that are being supervised across New Zealand, and a number of lawyers and accountants who do this work also are voluntarily agreeing to be subject to the regime, although they're not required to do so. So to suggest somehow that there is no oversight at all is not right, but we do accept that there are a number that are not currently being covered because the work is being carried out by a lawyer in the ordinary course of their business as a barrister and solicitor. We do agree that those need to be brought within the framework, and as I've said to this House in this contribution, and as I've said publicly, that is something that we have already made very clear. So the process of the work now is to work through with those sectors exactly how the oversight will work, where the regime touch points and levers are best set, and exactly who that supervisory agency should be. And that is a process that is progressing, as I say, at some pace. I get a lot of questions about whether somehow there's been some big campaign from these sectors that they don't want to be in the regime. I can certainly tell this House, I meet regularly with the New Zealand Law Society, as you would expect as a Minister of Justice. They have been well aware that this is coming at them, and actually as an organisation are very comfortable with that. I'm not going to say that every one of their 12,000 odd members mightn't have a view, I'm sure some of them do, but the organisation that speaks for them, the New Zealand Law Society, has been very relaxed and accepting of the fact that anti-money laundering regime is going to come into place for lawyers and in the time frame we've discussed. It's worth mentioning that there is already the Financial Transactions Reporting Act which applies to them, so they're not completely without oversight at the moment, but certainly the AML regime is significantly more comprehensive. The real estate agents similarly have certainly not raised any concerns with me. I haven't met with them on it directly yet. That process is getting underway now with the consultation, but they've certainly seen the media reporting and they've made no representations to me whatsoever that they don't think they should be in, and neither have the accountants. So there is simply no truth to the sort sort of implied argument that somehow we're getting a lot of pressure from the sector to leave them out. They all know it's coming. They're up for that. They do have an interest in ensuring it works well and is efficient, and as do we. But just to be very clear, Mr Speaker, the one point where the Prime Minister said most of the recommendations, it is around that. Yes to the process, yes to the substance, yes to the recommendations, but to simply suggest that the OIC process would work in place of primary ledge is unfortunately not right, and I believe the time track we're on is the most responsible and effective one.
Grant Roberts.
Mr. Speaker.